My recollection is there are 18 current permits issued by DHS for bulk water transports. I think 13 of them still stay in DHS. Large ones, and I think Poland Spring folks, Tom probably knows better than I do, but I think that most of Poland Springs operations now are going to be transferred over to DEP because they have real large extractions in their areas. What was not mentioned earlier, I think which is important, is that we're focusing now upon the somewhat surrealistic area of interplay of international law and states. Last time I checked, the 10th Amendment that was adopted in 1791 was adopted prior to GATT. And the 10th Amendment, of course, is a very important amendment because it is the source of the state's police powers, which are used, among other things, to protect groundwater resources. Also very important in our state, very important, are our local rights. Local governments have been very forthright in Maine in trying to protect their water sources. And this is a real challenge because in many cases, large groundwater extractions are located in rural areas that are not heavily populated, and so it's a challenge for local governments to really have significant technical review. But our statutes, and I cite to you the statute in our Water for Human Consumption Act, which is in Title 22, Section 2642, it does basically allow municipalities to chart their own course on water extractions. And so that's an important point, and a proposed extraction has to survive local review before it comes to the state for final approval. And I also cited in the materials the home rule provision in Maine's Constitution and statute 40 years ago now. 40 years ago, the Maine voters did, in fact, adopt municipal home rule, which, as you know, provides that a municipality can use its local ordinances to establish, to protect the public health, safety, and welfare as long as the municipal ordinance is not repugnant to or contrary to an established state law or state policy. And so I do think that in this overall discussion about the interplay between federal trade regulations and state activities, it's very important to also be cognizant of our local partners. They play a vital role and a critical role in the overall protection of our resource. That is a very quick sketch.
This heard from the State Planning Office and the land use team. And I wanted to just clarify that point you just made on municipal capacity. Would the international treaties not reach down to the municipalities as a sub-federal group the same way that it does reach down to the state as a sub-federal group?
The question, of course, is would a municipal government be a sub-federal? I don't know the answer to that question, but I also had I had the same thought. Like many of you, or certainly me, I mean, I'm actually very surprised to learn of this surrealistic solipsism known as international trade and how it might compromise the integrity of state police power exercises. So, but I would imagine that any kind of a sub-government would include not just the state, but also the county or the municipal government, I would think.
The last session, I put a bill in to put our surface, our groundwater in a public trust. I believe our surface water is in a public trust, but our groundwater is not in a public trust.
That's right.
And I put the bill in basically on Vermont's bill that they put in probably 3 years ago, where their ground and surface water both in public trust. Would you, in your opinion, as an attorney, say that our protection of our groundwater is as good as Vermont's is? Or why would anybody be against treating our surface water and groundwater the same?
I certainly would say this. If Maine only had absolute dominion, I would say it would be clearly inferior and inappropriate in terms of the method to protect the environmental resource. It's a policy matter, obviously, for our legislature and our governor as to what particular tools to deploy to properly secure our environmental protection. But I think it's a fair statement that although reasonable folks can disagree upon the tools which are used, the armamentaria that Maine has used to safeguard the quality and quantity of its groundwater resources have certainly have been rational and related to the various uses of groundwater in our state. And I think Carol, when she spoke about the uses of groundwater, I think she pointed out the various uses there are. So it's a policy matter. There are people who feel very strongly that public trust should be extended to groundwater regulation as well. The other question was, would public trust be better than the current array of regulations? I guess I'll defer to you folks. So that it comes down to I think a policy matter for legislature in terms of what works best. My limited understanding, I don't purport to be a constitutional lawyer, there would clearly have to be a mature and sober discussion about the takings clauses in the federal and state constitution if one was going to talk about a significant change from migrating property rights from absolute dominion to public trust. And so there is a case law, I know Peggy can speak much better than I can on that issue, but I do think it's a fair comment. States that have gone that way, Hawaii, I believe Hawaii has gone to public trust for their groundwater as well. And that has been a fair question, which at least we would certainly invite policymakers to consider carefully the takings issue if they were going to seriously look at public trust to supplant another type of regulation of groundwater.
Regarding, I have the Vermont law. Could you be willing to sit and talk to me and look at the Vermont law and discuss Maine law with me?
I certainly would, although I'm not a policymaker. I'm just a lawyer and a resource person, but I'm more than happy to assist the legislature.
One of the things that came up was this issue around municipal utilities, permitting. Are there areas of that may be under a different mechanism, whether it's public trust or whether it's additional regulatory provisions, we might want to know about?
Well, I would say, I just in passing, I heard the discussion about, was it the Kennebunk, Port and Wells Water District? And that would be a beguiling issue. I mean, that's true. And that would be, I'm not certain that the intent of the crafters of the amendment 2 or 3 years ago contemplated that circumstance. And so that would be a matter that I would think legislature would want to look at carefully and see whether that exemption, if it is an exemption, is that consistent with what the legislature had sought when they transferred regulatory responsibility of the large transactions over to DEP. Having said that, I'm probably not the best person to ask that question to. Someone like Roger Krause in the drinking water program who has the broad view. Drinking water, although it does concern itself with quantity of water supplies, I think Jeff had made reference to this earlier, a lot of what they do deals with the quality and the pervasive problems of contamination in water supplies. So I'm happy to provide further information to you right now, Representative, but I can't think of any problems, because most of my focus, honestly, is dealing with quality of public water supplies.
Yeah, my name is Chip Aarons. I spent 12 and a half years in the AG's office with Peggy, actually.
Long ago.
You remember, so be careful. Applies to you too. I remember hiring Peggy. And I was whispering to her that if one of these trade agreements, if somebody came along and threatened me, and I know how the AG's office would be, bring it on. But if Paul's thinking of the one loophole or gap, as you say, Senator Treat, is the Kennebunk Port situation. That was resolved last session, and to the extent that a separate well is established by the water district that would be used by Poland Spring or any other entity, that would require going to DEP for a NRPA permit. So that issue, which was raised by some people down in Wells, was resolved last session.
I was involved in the lawsuits.
Could you use your mic, please?
In 2007, and I don't remember that we didn't want to include them. I think that the intent was to have any of the major groundwater wells that were not concerned just with municipal water were to be included, no matter where the water was purchased, if they were purchased. I think I'm accurate in saying that.
The concept then was that the water district wells would not be considered significant groundwater wells for purposes of NRPA regulation, but wells that were to be used solely for bottled water would be. And so the fact that the well was going to be owned in wells, going to be owned by the water district, someone raised the question, oh, that means then that it wouldn't be regulated. And there was never an intent that a standalone well, even if it were owned by the water district, would not get NRPA review. So the language in the statute this past session was tweaked to make sure that the well situation would require an NRPA permit.